Hey everyone, it's Waneta at Cape Fear Family Law. It's good to see you again. So we're here today to talk to you a little bit about an issue that has been presenting a little bit more regularly here recently. That's supervised visitation. So I think that first we need to start off with the concept here that North Carolina is a state in which we value the relationship of a parent and a child. And we go to some extremes to protect that relationship. And so it's rare that a court will completely sever, at least in family courts, completely sever that bond. If there is a situation where a court is hearing a case where there are some concerns about the safety, well-being of the child when in the care, custody, and control of one parent, then the court has sort of in its tool belt the ability to order supervised visitation because they are concerned that unsupervised time with the child may result in some harm to that child. And so they'll find that supervised visitation is in the minor child's best interest, which, as you guys all know if you watch our videos, best interest of the child is the overreaching standard that all of our courts look at when deciding custody. So when the court finds that supervised visitation is in the best interest of the child, they have a couple of different ways to do it. And honestly, it just depends on the severity of the concern that the court has for the child's well-being. They can order that supervised visitation be done through a counselor or some sort of other professional, or they can order it to be done either by the other parent, if that's a convenient or a safe option, or through a family member, friends, those kinds of things, if those allegations or concerns are something a little bit more easily containable. And so we see these supervised visitation orders come in a variety of ways and cases. It could be something as minimal as, a parent who's been absent from the child's life for a period of time, and they just need some supervised visitation to ease back into that fostering the relationship. And that may depend on the child. If we're talking about an infant, 3-4-year-old versus a 12-year-old, there could be some differentiations there as to how long supervised visitation is necessary. We also have sort of on the other end of that spectrum, we have parents who have maybe some child abuse allegations against them, maybe some addiction issues, some domestic violence when the child is present that may have resulted in either emotional harm to the child. Things like this that the court says, I'm not completely comfortable releasing this child to you completely without any supervision. And now, just to also follow up on that, if a judge does order supervised visitation, it's not the end of the road. So a lot of our orders have what's called a phase-in schedule for supervised visitation. A phase-in schedule simply means that we will do supervised visitation for a period of time. It's a set period. Let's say 3 months, and I'm just making that up, but 3 months of a supervised visitation schedule. And then once that child is acclimated or there's some safety concerns are removed, we switch to unsupervised visitation. And then that unsupervised visitation continues. If there is no time frame given by the court, maybe the issue is severe enough that the court is concerned that it may not naturally progress, then you can always file a motion to modify. And a motion to modify can be filed in custody court, family court for custody anytime you can show that there has been a substantial change in circumstances that affects the welfare and well-being of the minor child. So if, for example, you are ordered supervised visitation with no end date, and let's assume for a minute that that supervised visitation is because of some addiction issues. If you can show to the court down the road that you've been clean for a certain period of time, you've got clean drug screens, you've got counselors who can attribute or attest to your sobriety, and you can show these steps that you've been taking to protect your child, bring that to the court and they can remove the restriction of supervised visitation. One more piece of supervised visitation I think we need to talk about is sort of a self-help supervised visitation, and we see this a lot, where mom or dad has the child, physically has the child, and there is no court order for visitation or custody. And if one of those parents is not sort of up to the standard of the other parent, then the custodial parent, the one who actually has possession of the child, will mandate that the other parent not see the child unless it's supervised. And I will tell you guys, if you're watching this, to be very cautious with these kinds of self-help methods. If it is appropriate, you could be applauded in court, but if it is not, that is considered alienation of affection of a minor child, and you can lose custody of the child because of those behaviors. And this all goes back to what I said at the beginning. Our court values the bond between both parents and a child. So we don't want to take any actions that would impair that loving relationship. And requiring supervision on a parent that don't really need supervision is alienation. And we reviewed another case, you can watch our video on it, in which the court recently said that parental alienation can make you lose custody of your children. So this is just sort of a cautionary statement to you that if you are using self-help and you are requiring supervised visitation, take a good hard look at it. And if your motives are not pure, if you don't truly have a concern for the safety and welfare of your child, and it's more out of anger or frustration or jealousy, stop. Stop doing it. Put your child first, and because the court will appreciate that more than you taking those negative actions. The other part of supervised visitation that we should address is, where does this visitation occur? And so when we're in the process of building and repairing the bond between a child and their parent, activities can be a great way to do that, right? So we can take them to jump houses or defy gravity, places like this where, age appropriate, of course, parks, playgrounds, where the parents can be interactive with the child during the visitation. I don't want you to feel like it needs to be in four walls in a stuffy room where you're trying to have this fun, loving relationship with your child. That's not it at all. So if you are in a situation of supervised visitation, start thinking about some creative ways to engage your child and to repair and build that bond and that relationship. And have fun with it. If at some point you are able to switch to unsupervised visitation, your relationship with your child will have benefited from that. So of course, many of you watching this, many of the clients here at our firm come in and they hear supervised visitation and they view it as a punishment. They view it as sort of this negative against them, and they don't want to do it. And my advice to them and to you is going to be, sometimes you have to do things you don't like. Sometimes you have to jump through hoops. Because at the end of the day, it's not about what you want, it's about what's best for your child. And even though you may love that child absolutely, and you are absolutely a good parent, that doesn't change the fact that your child needs to be comfortable with you unsupervised, and that may require a transition period. So my recommendation is that if it's appropriate, jump through those hoops. Do what you need to do to form that relationship, because at the end, again, it's going to benefit everybody, but especially your child. And it will benefit your relationship with that child. So just do it. Again, guys, thanks for watching. It's so good to be here. Just like, comment, share, and subscribe. And if you have any questions, we're happy to answer them. Just put them down below. Thanks, guys.